Welcome everybody. Hope you're having a nice Friday morning. Our session, as Jake mentioned, is in relation to insolvency. There's some quite interesting reforms which we'd like to speak to today. Just by way of background, my name is Daniel Zabow. I'm a partner in our litigation team. Presenting with me today is Courtney McDonald, who's a senior associate in our team. By way of further background, we specialise in banking and financial services disputes, including in connection with regulatory matters and insolvency and restructuring. We generally act for major banks and lenders, large listed and unlisted corporates and insolvency practitioners. In the context of insolvency matters, we act for all stakeholders engaged in the process and have had recent engagements in some of Australia's largest insolvency administrations, including more recently in connection with Arium and Virgin. We routinely advise creditors and insolvency practitioners alike on all aspects of insolvency matters, and we're proud to say that HWLE is recognised as a Tier 1 national insolvency offering. Turning to today's discussion, in particular, we're focusing on reforms to insolvency laws in Australia. We appreciate that most of you work for large institutional companies, banks, etc. So the focus of our presentation will be on providing practical insights into how these reforms may affect your business in particular. The new laws provide for a debt restructuring process, which are intended to give small businesses the flexibility to restructure debts while directors remain in control of the business, and for a new simplified liquidation process for small business. You should expect to see some restructuring proposals start to come across your desks, and you should be in a position to act quickly given the relatively short timeframes involved and the relative informality of the process. The reforms which were introduced through the Corporations Amendment Corporate Insolvency Reforms Bill of 2020 were in part a response to the economic downturn presented to us all by the COVID-19 pandemic. However, the push towards a more cost-effective and pro-debtor model has been discussed and theorised for some time, having been implemented in other jurisdictions such as the United States. Just to give you an illustration of the difference between pro-debtor and pro-creditor, a pro-creditor approach allows creditors to protect themselves against insolvency, generally by the availability of security and including over receivables, set-off, protection for good faith, and piercing of the corporate veil, whereas pro-debtor aims to maximise the defaulter's prospects to increase assets available for distribution and for the continued survival of the business driven by the director. In his recent second reading speech given late last year, the Treasurer, Mr. Frydenberg, said that these are some of the most important and significant reforms to Australia's insolvency framework in almost 30 years and were presented as part of the government's economic recovery plan. The changes are intended to help Australian small business to restructure and to survive the economic impacts of coronavirus, and give distressed businesses the necessary flexibility to restructure or wind down. The package of reforms feature three key elements. Firstly, a new formal debt restructuring process for small business to provide a faster and less complex mechanism for financially distressed but viable firms to restructure their existing debts, increasing the chance of them surviving and contributing to economic and jobs growth. Unlike the current voluntary administration regime, the new process adopts a debtor in possession model where the small business owner will remain in control of the business while a debt restructuring plan is developed and voted on by creditors. The plan is developed by the business owner in conjunction with an independent small business restructuring practitioner who will be referred to in this presentation as an RP. I think Courtney will remind you of what that acronym stands for throughout the course of the discussion. The safeguards are included to prevent the process from being used to facilitate corporate misconduct, such as illegal Phoenix activity. And they include a bar on the same company or directors using the process more than once within a prescribed period, and the provision of a broad power for the insolvency practitioner to stop the process. Additional mechanisms are also included as part of the process to ensure that creditor interests are represented and protected. The second part of the package is a new simplified liquidation pathway for small business to allow faster and lower cost liquidation, increasing return for creditors and employees. Unfortunately, due to the impact of coronavirus, not every business will survive, and liquidation is a path intended essentially to wind down the affairs of the company finally. Often liquidation costs can consume all or most of the remaining value of a company, leaving little return to creditors. And a simplified process is intended to retain much of the existing framework, albeit in a more straightforward method of delivery. Thirdly, the bill introduces complementary measures to ensure the insolvency sector can respond effectively both in the short and long term to increase demand and as to the needs of small business. The new process came into effect from 1 January 2021 and coincides with the end of the government's temporary measures to support business through the coronavirus outbreak. Those measures had a positive impact on allowing business to survive, with around a 50% decrease in the number of companies that have gone into external administration over the period April to August 2020 compared to the same period in the last year. Although the package reforms have indeed come into effect, they haven't yet found their way into the Corporations Act, but they will do in due course. So just by way of general overview, we'll be discussing briefly each of the following. Small business restructuring, which is the process for small business to restructure existing debts, which is quite similar to existing voluntary administration, save that the process adopts a debtor in possession model where the small business owner will remain in control of their business while a debt restructuring plan is developed and voted on by creditors. Simplified CVL, that is a simplified liquidation pathway for small business to allow faster and lower cost liquidation. And some other important updates, including in relation to safe harbour protections, whereby directors cannot be liable for debts incurred during restructuring. Anti-phoenixing laws, which are included to prevent and safeguard from corporate misconduct, and recent revisions to statutory demands and bankruptcy notices, including with respect to increases to thresholds and some of the discussion around what an appropriate threshold limit should be for a statutory demand or a bankruptcy notice to be issued. Whether in fact all of these reforms will have the profound effect which the Treasurer contends is yet to be seen. And as we'll outline, only micro business will be eligible, and even then they may not be able to get the benefit because of preconditions that are required as a threshold for the process to be available. The existing safe harbour regime is equally unhelpful for many SMEs because many are ineligible for similar reasons. Even if directors of business are able, it's questionable whether they'll be sophisticated enough to engage with these processes or simply will revert to the tried and tested model of BA or CVL. This seminar is intended to give a practical insight into how the reforms will affect you and to give you the tools to act quickly. Again, we're looking at this from the perspective of a creditor dealing with a company going through a restructuring, rather than descending into the minutiae of the requirements involved from a restructuring practitioner's perspective. Now, we thought it would be worthwhile just to give you a very brief background as to the existing framework for insolvency. As you can see, we've basically set out the modes of debtor-driven insolvency processes available, which include voluntary administration, deeds of company arrangement, and creditors' voluntary liquidation. BA is one of two formal corporate rescue and restructuring mechanisms available in Australia. The procedure provides a flexible mechanism that features an extensive moratorium to give the company and its administrator time to consider and propose potential restructuring options. That procedure involves 2 creditor meetings, with the final meeting allowing creditors to decide the outcome of the administration and what is to have to come of the company. Although no court involvement is necessarily required to undertake a VA, the court has extensive powers should it need to intervene. Part 5.3a of the Corporations Act was introduced following the Harmer Report in 1988, which was designed to implement swift, uncomplicated and flexible corporate rescue. At that time, that presented the largest change to the insolvency framework in Australia. A VA's powers are very broad as conferred by the Corporations Act and include taking control of the company's business, property and affairs, having the power to carry on business and manage the property in those affairs, the ability to terminate or dispose of all or part of the business, and to perform any function, exercise any power that the company or its officers could perform or exercise if the company were not in VA. A deed of company arrangement is one of 3 potential outcomes of a voluntary administration that are voted upon at the second meeting of creditors, and provides a very flexible mechanism that offers several advantages over other forms of restructuring, such as schemes of arrangement, which are much more complex and involve court appearances. Deeds do not require court approval and are voted on by creditors participating with the power to vote at a second meeting. A deed will involve a broad range of provisions with only a small number of mandatory requirements as prescribed by the Corporations Act. Creditors' voluntary liquidation, being the third option on the slide, also known as CVL, is a process that occurs when the company's members determine the company is insolvent, likely to become insolvent, or no longer able to satisfy its debts. As I mentioned earlier, liquidation effectively signals the end of the life of the company. CVL allows for the winding up of the affairs of the company without the need for court intervention. And this type of process essentially provides for the orderly realisation and distribution of the company's assets amongst its creditors and investigations as to why the company failed. So I think moving on now to what is essentially new to the insolvency framework, we'll hand over now to Courtney to discuss the implementation of the new reforms, starting with small business restructuring.
Thank you. Just some definitions that we'll be using throughout the presentation and which are dominant in the new legislation. So an RP or an SBRP is the Small Business Restructuring Practitioner, and they are generally a registered liquidator. There's some small adaptations to the requirements to be appointed. The restructuring period, which is essentially the phase where the plan is developed, and then the plan itself, where it's put into place and the creditors are bound. So as Dan mentioned already, eligibility is a key feature of the process. So it's really only micro and small to medium businesses that are going to be eligible. And the criteria will be met if on the day on which the restructuring practitioner is appointed, the total liabilities of the company do not exceed $1 million. And that excludes employee entitlements. So those all need to be paid up to date. It's also a requirement the company has not previously utilised the reforms in the last 7 years, and that also includes the directors, and that's intended to prevent, multiple companies, obviously, intended for related entities being placed into these processes.
So to stop a director from quarantining each individual's company's liabilities to 1 million and spreading it out across a multitude of related parties.
Yeah, and then tipping them all under. And the company can't be subject to another form of external administration, so VA, DOCA, CBO, as we mentioned earlier. So the definitions of the regulations include definitions for liabilities, and that's essentially the liability to pay an admissible debt or claim. So liabilities as at the date of the appointment includes all debts which would otherwise be provable in the winding up of the company, save for any debts which are incurred post the appointment of the registered registered liquidator, RP. So it's easy to see when you look at the definition of liabilities how quickly a lot of businesses will be excluded. It includes contingent debts and liabilities. So contingent liabilities are things such as damages, warranty claims. It's often difficult to adjudicate because they involve complex evidentiary and factual questions. Often we see, debts for, say, breach of a long-term lease. You're going to have future rent payable, and that's going to quickly exceed the $1 million mark. You've got a corporate lease together with some, bank debt and other liabilities. So really, only the smallest of businesses are going to be eligible, and tax lodgements essentially also need to be up to date. As at the date of the plan. So, if they're not as at the date of the appointment, then you're likely to be ineligible. So why $1 million? It might seem to be just a figure plucked out of the air, but ASIC apparently, they conducted a review between the 2018 to 2019 year, and they found that predominantly corporate insolvencies are very, very small, and they dominate the external administrations across the board in Australia. So they found 85% had assets of less than 100,000, and 38% had assets of less than $250,000. Sorry, liabilities of less than 250,000. So there was a really, I suppose, a poor outcome for the creditors involved in those external administrations, with almost, so it was 96% received 0 to 11 cents in the dollar. But in fairness, that's not all that unusual in all liquidations. So ASIC requested that the external administrators provide a report as to the affairs to see whether further action was warranted, presumably into director activities and the like. But only 20% resulted in further regulatory action. So I think just ASIC is, there's just simply too many jobs for ASIC to attend to. So the government has announced these amendments, and the amendments are intended, in their announcement, they said that they're intended to be directed towards small business, but there's actually not a definition of small business. It just is circular back to this definition of $1 million of liabilities. It seems a bit strange when you think about other statutes. So we've got the Privacy Act that defines small business as an annual turnover of less than $3 million. ASIC Act and the Fair Work Act are all referable to the number of employees. So generally less than 15 or 20 employees will make it a small business. So we're not really sure where the $1 million has come from, and it may be that that limit is increased at some later stage. At the moment, is it being utilised? Not really. Across Australia, there's been 3 appointments of small business restructuring practitioners, and 18 companies have published notices of their intention to rely on the temporary restructuring relief. So that's the simplified liquidation process, which is the next part.
And those numbers are extraordinary when you consider all the talk about the horde of zombie companies that I think this was intended to deal with. So it'd be interesting to see whether this flow increases and how many actually land on your desks.
Yeah, I mean, whether people actually know about it, yeah, might be some of the reason. So small business restructuring, we will try not to bore you with the intimate details of the regulations, but we do have a lot of insolvency practitioner clients who would be interested in those comments. But we'll just be discussing the impact to you as a creditor or a stakeholder, which is likely to have a claim in one of these restructuring plans. So the process is termed restructuring, and the debtor company comes under restructuring when it enters the process, and that's the proposal period there. So it's carried out by the small business restructuring practitioner or the RP, and as I said, they need to be a registered liquidator. Dan already mentioned, it's a simplified voluntary administration process, really, with a bit of elements of a sort of a bankruptcy debt agreement, which is a really key feature is that the directors remain in control throughout the plan and the restructuring. And this is a distinct move away from your traditional models where the insolvency practitioner is in charge of the company. Timing is around the same as a voluntary administration process. So from the time of appointment through to the proposal of the plan, and the plan being enacted is generally around 2 months, depending on how long, if there's additional disputes on claims and the like. So the timeline again up there, so the proposal period starts when the RP is appointed, and this is a critical date for secured creditors. It's the new vesting date for the PPSA, but it's retrospective. So with respect to, when you're coming back to, if there's a winding up, it will look back to that date. But it's otherwise the commencement of the decision period for secured creditors. So you need to be alive to when the RP is appointed and when you receive notice of the plan. The acceptance period starts when creditors are given notice. So that's the yellow tab there, and then they're invited to review their debt claim. The restructuring period ends when the company makes a declaration that the restructuring needs to end, the company fails to make the plan, a liquidator or some other type of external administrator is appointed, or the company successfully makes their plan. So that it's important to note that during the restructuring period, directors can terminate the process at will by giving notice to the RP and the creditors, and there doesn't need to be any reason for that. Similarly, the RP also has the power to end the restructuring process, and this has to be on specific grounds. They need to believe that the company either no longer meets the eligibility criteria, or they don't consider that it's in the interest of creditors for the company to undergo the restructuring. So the RP has an important role to play to monitor the company and the debts and claims that are being submitted. So some of the key terms that are in the reforms: affected creditors and excluded creditors. That's the actual definitions from the legislation. And what's key is that what's excluded are related creditors of the company. So affected creditors are anyone that will be bound by the plan, and excluded creditors is everyone apart from the restructuring practitioner, related creditors of the company, or any other RP that was appointed. So within 1 business day of the appointment of the RP needs to give to the creditors notice of its appointment. So this is when you'll get notice. So it's important that you monitor so your inbox, whatever the notice is, sort of email account.
The notices teams at banks or within your corporate function, critical to get early access to any notice.
Yeah, so the proposal period will then commence, and the company has 20 business days to prepare and propose the plan to the creditors. And while this period can be extended, it's only for up to 10 business days and otherwise by the court. And during this time, the directors work together with the restructuring practitioner in order to develop a plan for creditors. So during the restructuring period, the directors are able to trade the company in the ordinary course of business. And there are some exceptions if the RP consents to that. And key is that these transactions are not protected in subsequent liquidation. So the directors are responsible for these debts rather than in other forms where the insolvency practitioner would be personally liable for those debts incurred. So what's not in the ordinary course of business? Well, say if there's a satisfaction of an admissible creditor's claim, you're selling the business, or you're paying a dividend. So RP can consent to that. So I think it's important to just understand, especially if you're trading inventory, supply credit, anything like that, maybe just consider the terms of your terms and conditions of trade. If there's anything that you can roll eye upon, say for the ipso facto sort of insolvency reasons, to perhaps put your credit that company onto cash on delivery terms or the like. So what I was just saying there, ipso facto, you can't rely on a breach of the terms and conditions. So you can't rely on an insolvency event to terminate the contract. So it is an insolvency event once the RP is appointed. And that's applicable to all contracts dated after 1 July 2018 or variations entered into after 1 July 2018. So you can't wind up the company, you can't, if there's a current wind up application on foot, rather, proceedings in which the company is involved in are stayed, and you can't enforce director guarantees and guarantees from relatives. So it's intended to just allow the company a bit of a breathing room in order to get this plan in order. And third party rights cannot be enforced unless you're a substantial creditor. So secured creditors, which most of you are likely to be, so before the RP's appointment, of course, your rights are as normal. You can enforce your terms. During the restructuring period, depending on the type of security interest that you have and in what collateral it's in. So if you've got security in perishable property, then you can enforce. If you've got a possessory security interest of PIMSI, you can enforce and sell the asset. But if you have a surplus, you need to account back to the company. And the RP can consent to sales if you discuss what the plan is. Otherwise, third-party property rights are limited, save for if you have a security interest over substantially all of the company's property, then you can do as you like, but you've got 13 days to make a decision.
That mirrors the period that you've got in a VA as a secured creditor.
So the RP's got some protections during this. So they've got qualified privilege. They can, with respect to any statements that they make in the course of exercising their functions, and they're also protected from liability. So as long as they're acting in good faith, they're immune. They also have a right of indemnity from the assets of the company, and that indemnity is actually in priority to other circulating secured creditors. The right of indemnity will be over all of the company's unsecured debts. I said will be, that includes debts of the company secured by circulating security interest. The reason I'm focusing on this is that if you have an all-PAP, an all-present and after acquired property security interest, you will have security in the circulating assets of the company. So you need to consider whether you will appoint, because the RP's right of indemnity will be affected if a receiver is appointed or a secured creditor enters into possession or control when they have a circulating security interest, and that will essentially elevate the secured creditor in priority to the RP. So just depending on, because we all know that insolvency practitioners charge a lot, so there might not be many assets, so it's important to just have a consideration about whether you should be appointing a receiver once you get notice that an RP has been appointed. So after the RP is appointed and the proposal period has commenced, then we enter into the acceptance period. So the plan is proposed to the creditors, and at this point in time, the company is presumed to be insolvent. You'll receive from the RP a restructuring plan, standard terms, a restructuring proposal statement, which is your schedule of debts and claims. And at this point in time, you'll be asked to verify your debt and claim. So unlike a traditional, you lodge a proof of debt, this is you get told what your debt is and you can either agree or disagree. As I said, it's only debts which are incurred prior to the appointment of the RP. So that's when the line in the sand is drawn for the provable debts for the purpose of the plan. Now, the restructuring plan will be void to the extent it's inconsistent with the standard terms. So while the plan can be quite flexible, there are some standard features. So all admissible debts and claims need to rank equally. So this is the pari passu principle that we are familiar with. They also need to be paid out proportionately, and creditors can't be paid out more than the amount of their debt or claim. I struggle to see that will be a likely possibility, but nevertheless it's in there. And For secured creditors, depending upon whether they realise or do not realise their security and the level of their security versus the level of their debt. If they don't realise their security while the plan is in force and they stand outside of the plan to the extent of their secured property, and they're considered to be an affected creditor only to the extent that their admissible debt or claim exceeds the value of their unsecured claim. Exceeds the value of their security rather. So if you do realise, then you're only an affected creditor to the extent of any balance due to you after deducting the net amount realised. Essentially, if the level of your security is less than your claim, you will be bound to the extent of the balance.
And that reflects that to the extent there's a shortfall that's unsecured, you're effectively an unsecured creditor to the extent of that shortfall sum. Yeah.
So it's a curious little part of the restructuring reforms. But overseeing all of this, the RP needs to give a declaration, and they need to sign and state they believe on reasonable grounds that the company meets the eligibility criteria, and the company will be able to discharge its obligations as set out in the plan. So the restructuring practitioner is required to make reasonable inquiries of the company and to take steps to verify the information presented by the directors. Now, the registry, so a protective measure is that the practitioner will commit an offence if they make a declaration without proper inquiry, and that's a strict liability offence with 50 penalty units under the Corporations Act. So if you receive a schedule of debts and claims and you disagree with it, you have 5 business days to respond. So you must respond within this period. If you think you need further time, you can ask for it, but there's no guarantee that the practitioner will grant you additional time. So you need to lodge a notice of dispute.
And I think given the level of sophistication or lack of the likely participants here and the state of their records, it'd be really important to have a look at an updated statement of account and compare it as against what's presented by the RP.
Yeah, and if you disagree, then you need to substantiate your claim and you need to respond. So we'd suggest a current statement of account, all the relevant invoices if you're a supplier, and sufficient other information to substantiate your claim. So that might include, all of the loan account documents, all your standard terms and conditions, everything that supports your claim. If you dispute it, then the practitioner has time to consider and resolve that dispute and adjudicate. They've got a further 5 business days to do that. If at that point, the RP will then send you an updated notice of your schedule. And if you still disagree with the decision of the RP, then you can apply to the court. And the court can make orders that the claim be reconsidered or that the schedule of debts be varied. Otherwise, assuming no issues, you go into voting. And the acceptance period will end once the 15 business days have elapsed and all creditors have voted. So importantly, if you do not verify your claim, you cannot vote. So during this 15 business days, you vote. You can vote as many times as you like, and you vote by sending a written statement back to the RP. Approval is by a simple majority of value, so not of number and value, just of value of the unsecured creditors. And remembering that this excludes related party claims. So it may well be that, so you've also got only people that have verified and only unsecureds and not related creditors. So it might be that only 20% of the people that actually receive the plan will actually vote. And if it's accepted at the last day of the acceptance period and the majority of value of those creditors who have received the plan say that it should be accepted, then it will be. The determination of value is by reference to your admissible debt or claim as at the time the restructuring practitioner was appointed. Another thing is you can't purchase a debt or a claim and then vote for the full value if you purchased it for a discount. So if you purchase someone else's debt, then you can only vote for the discounted amount. So who's bound by the plan? All unsecured creditors are bound by the plan. Otherwise, if you're a secured creditor, you're bound to the extent that you're unsecured. Unless, of course, you are fully secured and you consent to be bound by the plan. You can, if you're a secured creditor, you continue to deal with secured assets unless you accept the plan and the plan says you can't do so. I'm not sure that many secured creditors will accept a plan, but it's something to consider, and it will also be, relevant to know the extent of your security. So the regulations also provide for the following protections of the company. So while the plan is on foot, a person bound by the plan can't make an application to wind up the company and can't proceed with an application made before the plan became binding on that creditor. So any admissible debt or claim that's provable in the plan, then that's not something that you can then attack at a later court date. And you can't commence or bring any proceedings if you're bound by the plan for any enforcement process against the creditors. So what happens during the plan period? Once the plan's made and it's implemented, the plan will determine the rights of the creditors and those bound by it. So that binds all creditors with admissible debts or claims. And a secured creditor, as I said, is not otherwise prevented from realising its assets. The provisions which provide for how the secured debt is taken to be treated under the plan are helpful because it essentially means the secured creditor cannot use the entirety of its secured debt to vote for or against the plan and sort of diminish the votes of other creditors. And secured creditors are ruled off as at the time of their plans commenced and only to the extent of the value of their secured property exceeds their claim. So whether you'll get paid and how much will be determined by the plan. And it appears it'll be a percentage type or cents in the dollar type calculation. And the RPs also are entitled to be remunerated, and they will include what they propose to be remunerated for in the plan submission. And it's also generally a percentage of the plan's payments made to the creditors, which they'll take. So what happens if it's terminated? So you can terminate for performance, does everything right, yay, tick, done, we're back to business as per normal. Might take less than 3 years, might take only a couple of months. But if it fails, then what are the options? So it can end prematurely if there's a condition of the plan that's not met. If an administrator or liquidator is appointed to the company. So whilst the creditors that are bound by the plan can't do that, you can otherwise fall victim to other winding ups, and there will be a court-appointed liquidator or the like, or otherwise the court just orders that the plan to be terminated. At that point in time, the company will revert back to the control of the directors upon termination of the plan. It's not an automatic transition into a liquidation or voluntary administration. This is because the directors are then given the option to determine which process they want to use going forward. So as you can see, we've either got the simplified liquidation process or your standard creditors voluntary liquidation process. And there's a decision period which the directors have to determine within that time if they wish to opt for the simplified liquidation process. So what's the difference here? It's pretty similar to your creditors voluntary liquidation, save that there's just the cut out the need for meetings and some of the reporting requirements of the liquidators, because that's a pretty big job if for the liquidators to undertake. They're meant to, trawl through all the documents and records of the company and determine, whether there's anything that needs to be investigated or if there's any wrongdoing or what have you. So they've sort of scrapped that requirement, the big report that you normally get. It's the same eligibility essentially for the small business restructuring. So again, only small companies are going to be eligible. There needs to also be the triggering event. So you don't need to be in the restructuring part beforehand. You can go straight from trading to opting for simplified liquidation if you meet these criteria. Again, you can't have done it if you're a director or a company, you can't have done it in the last 7 years. So it's very similar. So as I said, but if you are in the restructuring period and then the plan fails and then you opt to go into simplified liq, you must elect to follow the process within 20 business days. And so that notices thing that we showed you at the beginning of the presentation about people that have the 18 companies, they're the 18 companies that have elected to follow the simplified liquidation process. As I said, it's just the same really, but with no reports, no requirement to convene meetings, no committees of inspection. I mean, committees of inspection are only really for the really, really big liquidations. And there's also a requirement on the liquidator to report fraud, and there's been some changes to the avoidable transaction rules, which we'll come to at the end. So notice of intent to follow the plan. You'll receive a notice of intent from the directors of the company 10 business days before they adopt the process. Sorry, that'll be from the practitioner, and I think there's some sort of fact sheet that goes along with it, so you can consider whether you are happy to go along with this proposed pathway. The liquidator can't adopt the process if more than 25% in value of the creditors respond and say that they want an ordinary creditors voluntary liquidation. So related entities aren't included in that calculation either. And the liquidator must also stop the simplified pathway if they have reasonable grounds to believe the company is engaged in conduct that is likely to have or will have a material adverse effect on the interests of creditors or a class of creditors as a whole. And they must also believe that the conduct is fraudulent or dishonest. It seems like a pretty high bar, and I don't know whether many practitioners will be happy to make that call, but I think there'd have to be some pretty damning evidence. Again, so the RP, it's quite important. So at the beginning of the seminar, we're discussing the date RP is appointed. It's the relation back day for avoidable transactions, and it's also the new vesting date for unperfected security interest. So there's been amendments to the Corps Act to both Section 91, Section 513CA, and there's some additional stuff in the PPS Act as well. It's important because this is also, the decision period commences at that time, so it's important to be aware that that's now in place. Finally, so avoidable transactions have been changed by reason of if the simplified liquidation pathway is adopted. Generally, there's no limit on unfair preferences, but there has been changes here. So only within 3 months of the relation back date can those payments be clawed back by the liquidator, and they have to be more than $30,000, which is pretty substantial.
So the relation back period's half what it was. It was previously 6 months. It's reduced to 3 with the threshold on monetary limit. Yeah,
unless you're related, in which case you can be still targeted if it's less than 30. There's also there's no limit on insolvent trading, but that's the most sort of important change that's been made. So So that's really what we wanted to discuss in terms of the simplified liquidation process and the restructuring process. Otherwise, we've got some updates on the safe harbour regime. So I'm sure you're all familiar now. It was brought in September 2017. It was intended to provide directors with an incentive to try and save their businesses, even if they had a suspicion of insolvency, by providing defence, where they took one or more courses of action that are reasonably likely to lead to a better outcome for the creditors, rather than just simply placing it into liquidation.
So that is a defence to insolvent trading claims, so debts incurred for the duration of the period following which a plan is proposed for safe harbour.
Yeah, and so it also, any time when the company's insolvent, and you're incurring debts as a director, that's a potential claim that can be made against you. The requirements to essentially have the safe harbour defence available to you. You have to put a course of action in place. You have to have employee entitlements up to date. You have to have tax lodgements up to date. So most small businesses are not really that good at those sorts of things, and most of them won't be able to comply with the preconditions. And it's unlikely to be, so these new reforms are also unlikely to be used by small businesses in our opinion. You'll recall that the COVID temporary relief ended on the 31st of December 2020. There was a ban on insolvent trading claims really throughout the calendar 2020 year, and the new reforms just provided defence, as Dan already said, for the period of time in which the company is in restructuring. So not clear yet whether it's actually going to be utilised. There was a recent decision in Melbourne where the court rejected an argument by the managing director. This wasn't the new reforms, but just an example of how the defence is trying to be used. The small cafe business, and he said, well, if the director starts to put together a plan that has a chance of putting the company in a better position, that plan can be implemented and the company turned around, and the directors will not have to be concerned about the prohibition on insolvent trading. The cafe had a lot of trouble paying its creditors. Its computer records had been destroyed due to a computer malfunction. We've seen this before. Things get destroyed, burnt, thrown off bridges. And the managing director just simply could not cope. So the company stopped filing tax forms. It got behind on its employee tax obligations, and its tax debts were over 100 grand. The directors were dipping into their own pockets to float the company, and the ATO had issued garnishee notices. It was quite clear that the company was insolvent and had been for some time, several years in fact, and the director attempted to argue, well, I've been using my personal assets, and I've got access to external finance, but the court was not satisfied. Safe harbour was not available as a defence because it didn't meet the preconditions. The tax lodgements were out of date. No employee entitlements had been paid, and they couldn't point to any plan that they put in place to ensure that a better outcome for creditors. So again, you need to be able to meet the requirements in order to have the defence available to you.
I'm not sure who advised them as to what prospects at all they would have had of any success in court, but anyway.
If anyone wants to look up that case, it's 2020 VSC 652. So stat demands. So last year there was a temporary increase in the threshold to file, to complete a creditor's statutory demand. That was raised to 20 grand. That expired at the end of last year. Treasury submissions are open to today as whether there should be a permanent increase in the threshold to 20,000 or some other amount. Bankruptcy notices have permanently been increased to $10,000 as of the commencement of this year.
Probably fair, given that that's really the threshold for the small claims division of the local court, and because of the draconian consequences of bankruptcy 2,000 was simply too low as a threshold entry to a bankruptcy notice being issued.
Yeah.
So I think at $10,000, it'll be interesting to see whether the threshold is equally lifted, at least to that level for stat demands.
Yeah, and it's not really, despite what everyone thinks, a process for debt recovery. It's actually an abusive process to use creditors' statutory demands to compel payment of a debt. But I think that's, it's also part of the reason why there's intending to increase the threshold so that we can, it's really just for genuinely insolvent companies for there to be a procedure to wind up the company if they fail to comply with stat demand.
It's really to establish a presumption of insolvency. So, although often used as a debt recovery tool, not the intended purpose.
Other changes, so throughout the course of the presentation we were discussing this can't use the process if you've been through it in the last 7 years or any of your other companies of which you're a director. That's intended to prevent phoenixing. There's also a change where you can't, directors, so that was only just on 18th February 2021, the director resignations changes came into effect. Whilst it's been in place for some time, there was a transition period, and you can't now backdate your resignation if you're a director. Or if you cease to be a director and leave the company, and this is to essentially close the loopholes which are previously being utilised for phoenixing. So key takeaways from presentation today. So eligibility, you've got to have liabilities less than 1 million, employee entitlements up to date, can't have used the process within 7 years, and tax lodgement essentially also need to be updated as well. You've got the proposal period is 20 business days. You've got 5 business days to respond, and once you receive the plan. So during the proposal period that's all being prepared, your property rights are restricted. Acceptance period, you can challenge it if within the 5 business days. You've only got debts are admissible to proof up until the last day of the acceptance period if it flips into LIP, but otherwise it's a admissible debt up to the date the RP is appointed, and creditors vote on the value of their debt. The plan, it can be in place for up to 3 years. Secured creditors, owners and lessors are not affected unless they consent, or if their debt exceeds their security. And all secured admissible debts and claims will rank equally. Ooh, I went too fast. Simplified CBL, that's a pathway that can be adopted again if you meet the eligibility requirements. But if you're not satisfied and you're a creditor that you, I don't know why you would. I'm not sure what the reasons are that you might not choose to adopt the simplified liquidation process, or sorry for the company too. But if you just choose to vote against it, then they will go into a normal liquidation process. That's otherwise our presentation, and if there were any, we're just sort of thinking about how it might be utilised this year and whether there will in fact be many more appointments. But
I think what we will see this year with the movement away from government support is an increase to the number of insolvencies. I'm not sure that this mode of restructuring is going to be available to many small businesses because of the eligibility requirements. And what that is going to trigger is an increase in the number of liquidations and voluntary administrations. And I think in that context, it'll be interesting from the perspective of any creditor, unsecured or secured, as to how you respond to any restructuring process that's presented to you, and as to what rights you might seek to enforce upon being notified of that appointment. I think the key takeaway from this, for any creditor's perspective, is to evaluate your position as soon as you can upon the giving of notice, given the relatively short time that you've got to respond, and the fact that the onus is flipped to an extent in that it's not the usual submit a proof. In this case, you're being told what your debt is. So in that regard, I think it'll be important to take stock, look at the position, act quickly, and if you need to take advice, particularly as a secured creditor, as to the extent of your security, the extent to which you may be bound by the process, the extent to which you may seek to avoid what may be an adverse consequence of the restructuring practitioner having a priority over secured debts if action isn't taken, that steps are at least considered based on the value of the security.
I can just see that we've got a question come up on the slides here. So what practices could banks establish to prepare for small business restructuring? And are there any prudent steps that the bank as a secured creditor could take when they receive a plan? Well, as we mentioned, I think you need to have, so for banks, you normally have a sort of a notices team or someone that's going to be receiving these types of communication. So you just need to be alive to the fact that this is a new category of submission that you'll be receiving. Have someone able to action that relatively quickly, who's competent and who's able to sort of, right, like Dan said, establish quickly the value of your security and notify the relevant persons in the team in order to perhaps, you know, get all the relevant documentation together. If you've got security in, you know, something which is a little bit difficult to assess the value of, you know, say you've got a circulating security interest in inventory, you might need to consider taking a stock take because you are the one that has to assert the value of your security, and that's not always that easy with some other types of assets. Prudent steps, I think you just need to educate the team beforehand. You know, come talk to us, but you know, just have something in place so that they can be actioned relatively quickly. And I think the first thing you could just respond instantly, notify that you've got a copy of the proposal and that you will be responding, just to let the practitioner know that you're on the case.
I think that's all sound. Having an escalation policy to deal with a notice once it's served, and then taking those steps to establish the debt level and whether the security exceeds or is less than the value of your security.
Yeah. Well, we hope you enjoyed today's seminar.
Any questions, feel free to give us a call.
Yeah, or an email. Thank you.
Thanks, guys.